influence of campaign funding. Do you believe it is important to reduce the influence of campaign funding in judicial elections? Or do you believe that such funding even has influence? And I would like to contrast this. One thing that I notice in perusing the candidates' homepages is an organization doesn't just give money, it can also endorse candidates. So there are all kinds of different free speech activities organizations can and do partake in. And is it really fair to draw a line between contributions, say, or endorsements, or other kinds of support, which people no doubt have a right to give to candidates whom they believe in? So ultimately, though, is it important to reduce the influence of campaign funding? Does it have an influence? State Senator Skindell.
I think by human nature, campaign financing, when you have folks contribute to judicial campaigns, you're undermining the goal of being fair and impartial at all times. It does have a role. It's part of that human nature. We as candidates pledge to try to pull ourselves away from that and try to be, when we actually become justices or judges, to be fair and impartial when those cases come before us. My belief is, here in Ohio, we have a system that is a system that, to a certain degree, is made for failure. We try to promote fair and impartial judicial races, but we have our candidates run in partisan primaries, and then when we get to the general election, there's no DNR next to you. We put financing, private financing into these campaigns. There's limited regulation. What I support, I believe that we should try to get a cleaner system. If you're going to have partisan primaries, the general elections should be partisan. If you want to remove it out of the system, remove it totally out of the system. With regard to actually campaign contributions, I have advocated for public financing of judicial races similar to that in the state of Arizona. It has had great success in trying to remove the influences of money in these elections, and I strongly believe that the state of Ohio should examine that model.
Thank you. And Judge O'Neill, same question to you.
I think it is imperative that we all, judges, politicians, and citizens, take a look at this and understand the corrosive effect that we've been experiencing in Ohio since 2000. These judicial races for Supreme Court of Ohio are topping out at $1 million now. That's what it takes to run a good TV campaign. You know, I ran for Congress 2 years ago, so I know TV and I know fundraising. In the judiciary, it's different. Judges should not be taking money, and I guess I look back at the thought that every journey must start with a single step. I think as a matter of an imperative, there should be a prohibition in Ohio that anyone who has an active matter in front of a judge is prohibited from giving any money to that judge. And as Senator Skindell said a while back in the Plain Dealer, refuse or recuse is the rule that should be applied. If you have an active member on your docket or a matter on your docket, you just don't take money from those people. But I can take it up a level. 6 years ago I proposed, and I still propose. Put $10 on the court costs of all the people who are clogging our dockets right now. Every lawsuit in Ohio, put a $10 court cost on that lawsuit, create a judicial education fund, and in that fund, then judges would be paid to get their message out to the people, but by taking that public funding, they would be prohibited from taking money from anyone. It is a system that is crying out for an answer. The answer is money and judges don't mix. They never have and they never will.
Let me ask a follow-up question on this point, because I did mention the issue of endorsements, and I want to know, just if you could in 30 seconds, Judge O'Neill or Senator Skindell, maybe 30 seconds to a minute, well, where do you draw the line? So if you say campaign funding, that kind of support is not okay, but endorsements are still okay, it seems like you're on a slippery slope to the point where you put a gag order on people who want to support candidates who also have important issues that may end up before the court. So how do you draw that line in a non-arbitrary fashion? Why choose money and not other forms of support?
Well, because this is America, and we have freedom of speech. And the problem that I see is that we're trying to limit speech. For example, the United States Supreme Court has said money is speech, therefore cannot be limited. Well, then why is it limited? Why can people only give me $3,500? Why couldn't they write a check for $35 million? The problem is, money is not speech, but you can't start limiting what people can say. I'm endorsed, freely admitted, by 1 million labor people in Ohio. Endorsed. They like my candidacy and they like my message. Certainly I would not be advocating that I can't rule on any cases that involve organized labor or injured workers. It's a fine line, and that's why I say every journey starts with a single step, and I say the single step is, if you're in front of me, you can't contribute to me.
Okay, thank you for that. And back to, with those issues crystallized, onto Justice Cupp.
Crystallized? Do you think they're crystallized?
No, I think they're actually gotten a little fuzzy. But, so let's try to clarify things a little bit. We have a system in Ohio, under the Ohio Constitution, that we elect our judges. And when you elect judges, that means that the candidates have to be able to inform the voters, because as we've already mentioned, judicial races are very much under the radar, and people don't know who the candidates are, and they don't know how to evaluate candidates for judges. So you run a campaign, and part of the campaign is providing information to voters so that they can make that decision. Unfortunately, I've not found any TV or radio outlets or newspapers in this state who are willing to run advertisements for candidates without charging them. So in order to be effective, you have to have money that goes in there. Now, we have very strict limits on what judicial candidates can do in Ohio. First of all, the candidate themselves cannot ask anybody individually for money. They cannot accept money from any person. You have to have a separate campaign committee with a separate finance director that is sort of builds a little wall between the judicial candidate and the campaign. And there's only fundraising is only allowed 1 year out of 6 in the year in which the judge is elected. So this is a balance that has been created to be able to have informative campaigns and yet to have some restrictions on the role of money in the campaigns. And I think that's an important distinction that we have to have. Unless you're a candidate that has lots of personal wealth, you simply cannot run a statewide campaign and inform voters without some type of support. The rules of judicial conduct provide that when contributions are within the limits that are established, that those do not create any impropriety in reality or in appearance. And what really boils down to is that we must ensure that the people that we elect have character and integrity and a commitment to applying the rule of the law, and the law decides the outcome of the case, and the chips fall where they may. And so that is why it's very important for voters to carefully evaluate the candidates and their backgrounds and reputations and beliefs.
Thank you. And Justice O'Donnell, same question to you.
Thank you. Ohioans have rejected the notion to change the fact of electing judges in Ohio. It was posed to the electorate as a constitutional amendment, and it was resoundingly defeated. The public has control over the elected members of the judiciary in the state of Ohio, and the public adheres and seeks that public accountability in the course of our elections. Given that, the responsibility to provide regulations for the conduct of judicial campaigns in Ohio rests with the Ohio Supreme Court. We're aware of the continuing perception that there may be an influence of campaign contributions in judicial campaigns. I can tell you there is no cause and effect relationship existing, as Judge O'Neill would have you think, between a campaign contribution and a case result. There's no evidence of that anywhere. The fact is that judges are not permitted to accept contributions in Ohio because we regulate that by having them develop a campaign committee for the purpose of raising funds. And those committees are charged with collecting the money, reporting the money for full transparency. This is the way it's been done in Ohio. It's the way it's been done by all 730 judges and candidates throughout our state for a decade. We regulate the minimum and the maximum amounts of contribution that can be made, and those numbers vary for trial courts, intermediate appellate courts, and state supreme courts. Furthermore, we review this matter at the Supreme Court on a regular basis. And it's interesting and I think instructive for all to know that the Code of Judicial Conduct permits judges to accept contributions to campaigns in accordance with those limited regulations and conduct their dockets. And the comment to Rule 2.11 regulating those conducts says this: a judge's knowledge that a lawyer, a law firm, or a litigant in a proceeding that contributed to the judge's campaign within the limits set forth in the rules or publicly supported the judge does not, in and of itself, disqualify that judge. Now that's the regulation that we have in Ohio. It's been there for a very long time. And when our court adopted it, we put it out for public comment. There was no comment from Mr. O'Neill at that time about it. He didn't participate in the committee, didn't have any comment. It's only when he gets a personal gain by making a public statement just before an election that we hear this. The other thing is, I would ask Mr. O'Neill to regulate the fact and admit to the public that the allegations that he raised earlier in describing his background, which challenged Justice Cupp and my receipt of a contribution from First Energy, was the subject of a grievance that he filed. And he hasn't had the integrity to tell you that grievance was determined by a panel of 3 judges to be no conduct violating the Code of Judicial Conduct, and that no good cause is found for investigation of grievances to exist. And he hasn't had the integrity to tell you his complaint was dismissed, and these charges are false.
Thank you for that.
Sure.
We have
I must respond.
Judge O'Neill take a moment to respond since your name was mentioned in Justice O'Donnell's remarks. Just a moment, please. Then we have to move on.
Yes, it's the old integrity question. The reality is that disciplinary proceedings in Ohio are confidential. The only person that is permitted to disclose the outcome of a disciplinary complaint is the person against whom it was made. Without hearing. The Supreme Court's disciplinary arm said there is no appearance of impropriety if you take a $6,300 contribution from a litigant 2 weeks after oral argument. No appearance of impropriety without a hearing. It is the problem. The other problem that Justice O'Donnell raises: these committees are frauds. Let's be grown-ups about this. A judge puts together a committee. The committee holds a cocktail party, and the judge goes to the party to thank the people who were there. That's fraudulent conduct. It is the emperor has no clothes.
So that's 1 minute, and Justice O'Donnell's name was mentioned. I don't know if you want to respond to that, or we can move on to the next question. Otherwise, the next question is for you anyway.
Mr. O'Neill is not my opponent. Perhaps Justice Cupp should have an opportunity to discuss that.
We're so used to being
I will
opponents.
tell you, however, that Mr. O'Neill had no problem blast faxing the media in Ohio when he filed the complaint, even though he now admits publicly that he knew it was a violation. The sad part is he has not the integrity to tell you until it's brought to him. that it had been dismissed more than 2 weeks ago.
We are going to move